For many years, the American railroad industry had little competition for its long-distance freight business, which was key to economic viability. But the rising success of the trucking industry following World War II prompted the railroads to take certain actions to combat trucking's increasing popularity. In Eastern Railroad President's Conference versus Noerr Motor Freight, we explore the intersection of those actions and federal antitrust law. 24 railroads and an association of their presidents hired a public relations firm to conduct a publicity campaign to encourage state legislators to adopt laws detrimental to trucking. Specifically, the campaign highlighted alleged damage to roads, violations of weight and speed limits, and failure to pay a proportional share of road construction and maintenance costs. In response, the trucking industry launched its own publicity campaign, primarily to influence legislators to adopt laws favorable to trucking. Both industries' campaigns utilized the third-party technique, in which third-party statements were portrayed as spontaneous when in fact planned by the campaign. After the railroads campaign prompted Pennsylvania's governor to veto legislation favorable to trucking, Pennsylvania truck operators and their trade association sued the railroads, the Eastern Railroad President's Conference, and their public relations firm. The truckers alleged a conspiracy to restrain trade in and monopolize the long-distance freight market, violating the Sherman Antitrust Act. They claimed that the sole motivation for the railroads campaign was to destroy trucking as a competitor. In response, the railroads asserted a counterclaim, raising essentially the same arguments about the trucking industry's campaign. The district court held that the railroads campaign violated the Sherman Act, while the truckers' defensive campaign didn't. The railroads appealed to the Third Circuit, which affirmed, and the United States Supreme Court granted cert.